Rahul, and thank you everybody for joining us. I know it's been raining webinars, so I really appreciate you taking the time and joining us on this webinar. We live in extraordinary times and times that require innovation in solving practical problems. And webinars like this present webinar are proof that whenever the human race is faced with challenges, we come up with new ways to solve practical problems. I I see a lot of my friends from different parts of the world also joining. So thank you for taking out the time. I realize that it might be difficult for you given the time zone. Um, Let me start with giving you a broad outline of what we will be discussing here. In sum, this webinar should help you answer a few questions. What is third-party funding? What is the need for third-party funding? What are the key concepts involved? And broadly, how does it work? Now, let me also tell you what this webinar is not about. This webinar is not a session lauding the merits of the arbitration system. In fact, on the contrary, today I will talk about a major problem in international arbitration of high costs and a cost financing model that has developed in response to the high costs. What I say here may also be applicable to litigation financing or even informal financing, but I will restrict myself, and this session is primarily aimed towards financing of arbitration claims, especially in business to business or business to sovereign disputes. And that is simply because I don't want to talk about areas that are beyond my own expertise or experience. This webinar is also not legal advice. I'm sure you already understand that. And the objective primary of this is for educational purpose for students who are helping fight the pandemic by staying indoors. I'm also not here to promote third-party funding. I have no affiliations with any funder and no particular personal interest in third-party funding. But having experienced it, I do feel that it fills a gap, a much needed gap. And this mechanism is here to stay. Given the current economic climate, the need for third-party funding becomes even more relevant. I also had trouble narrowing down the topics for this webinar because there is just so much to talk about and so little guidance available. I remember when we first started trying to find out how to go about it, it was an uphill battle. So with the caveats out of the way, let me start by discussing the problem of costs in international arbitration. The most often cited example of high costs in international arbitration is the case of UCOS versus Russia. In that case, the winning party was awarded by the tribunal legal costs of 60 million US dollars or about 450 crore rupees. Now, most arbitrations today don't cost a fraction of that. However, the cumulative expense of fees, counsel's fees, experts' fees, tribunal fees, and the cost of hosting hearings becomes increasingly burdensome for most clients. In fact, a lot of sophisticated arbitrations require additional services like translation, transcription, video conferencing services, and all of these are very expensive. Remember, there is no pro bono in international arbitration. However, there's still a need because a lot of companies do have trouble financing their disputes. Additionally, arbitrations are risky. You cannot completely predict with certainty how much budget you will require to litigate a particular matter. And given the fact that while arbitrators follow a cost follow event principle or the loser pays principle, that comes at the very end of the arbitration award. And it's sometimes a few years down the line from when you start an arbitration process. And those few years require a lot of funding to be able to pursue the claims properly. Now, there are times when we have very limited budgets, and that puts the that puts a party in an obvious disadvantage, because a lot of times, for example, the respondent in an arbitration would like to take the strategy of bleeding the other party dry by making the process extremely long and cumbersome, by filing unnecessary applications, and the budgets as a claimant that you initially start with just expand, and you can't help it. Now, I see Josephine has said, asked me the name of the case. Yes, the name of the case that I was referring to is Yukos versus Russia. And let me just share my presentation here. I don't plan to rely much on this presentation, but yeah. So Josephine, this is the case Yukos versus Russia. I've even provided a link to this, and the specific paragraph I am referring to is paragraph 1887. Now, this award is publicly available, and you can go have a look at it in your own time. Quick personal criticism. I think while the tribunal has awarded a very high cost in this, I think they have not spent substantial time in actually explaining the jurisprudence behind awarding costs in international arbitration. And that is a major issue that we often face when making cost submissions. Okay, I'm going to stop sharing this. Yeah. Now, as I was talking about, this often leads to a situation where the other party is employing guerrilla tactics just to frustrate the claimant in pursuing their disputes. So now that has given rise to third-party funding. Third-party funding has been born out of the problem of high costs in international arbitration. Third-party funding simply means getting funded for the cost of an arbitration. It can begin at any stage in the arbitration process, and it is essentially a transaction whereby a third party to the dispute funds the arbitration, and in return, it receives a part of the winnings of the case. It is a financing model which collateralizes the claim and helps with the litigation costs. Now, what do I mean by collateralizing the claim? It means that the asset against which you are taking money is your claim in the arbitration. And this is very useful for parties, either, for example, small or medium enterprises who find it uneconomical to pursue an arbitration despite having a valid claim, or even for situations where big corporates just find it unfeasible, or for other strategic reasons do not want to invest a lot of time, effort, energy, and especially money and resources into pursuing an arbitration. Now, at this stage, let me share my screen again. And yes. Now, who is a third-party funder? A third-party funder is somebody who's a person or an entity who is not a party to the dispute. So the third-party funder does not have a direct personal interest in the outcome of the litigation or the arbitration, but who contributes funds or other support. Now, funds, financial resources, or other support, for example, providing expert witnesses for free or things like that, under an agreement. So there has to be a funding agreement in place to a party to pursue an action and in exchange anticipates a benefit. So it is a transaction whereby by providing support, the funder is anticipating something in return. And in terms of commercial funding, their role is very similar in some ways to a private equity funder who's investing in a project or a startup or things like that. Broadly, from the investor's perspective, he is looking to make money. Arbitrations where you are relatively confident about the outcome are a comparatively safe bet compared to many other financial instruments that may be available in the market. Now, third-party funding is not a new concept. It's been around forever, and it's been there in informal ways in, for example, land disputes and other claims. And India is an example where informally third-party funding is very common. However, I am talking here about structured and organized third-party funding. And the decade of the tens, and yes, that's how we will remember the last decade. The decade of tens really brought a dramatic shift in this area, with a lot of mega third-party funders cropping up in different parts of the world, but providing their services globally. And that has brought a lot of structure to the concept of third-party funding. And let's look at a few key concepts here. And one of them is that third-party funding is a non-recourse funding. Now, non-recourse funding essentially means that if a funder funds a claimant and the claimant eventually does not win the arbitration or is unable to recover any funds, the funder does not get paid anything. So the funder is in some ways assessing the quality of the claim and then, in a manner of speaking, betting money on it with the hopes of a win. But in case there is no win, the funder does not get anything. Now, as I said earlier, arbitration usually follows the loser pays principle, which means that in the event that the claimant loses an arbitration, it also has to pay the legal costs of the respondent. So for this, there is a concept of after the event insurance, which a lot of funders insist on, because in the event that costs are awarded, there is a risk that the costs may actually be awarded against the funder. And the funder has already paid for the claimant's legal fees, and at the end of it also runs the risk of having to pay the respondent's legal fees. And therefore, some funders insist on an ATE insurance, whereby in the event that the claimant loses and it's supposed to pay the costs of the respondent, that amounts are insured. Now, to take care of another concept is security for costs. Now, we often see that when there is disclosure of third-party funding, that means when a claimant goes into arbitration and tells the tribunal that, look, I've been funded by XYZ company and they will be supporting me with resources in pursuing this claim. At that stage, a lot of respondents seek security for costs, or basically an amount to be put in a separate bank account or an escrow account, which is there in case the respondent wins at the end and wants to recover security for costs. And most jurisdictions have provisions for security for costs. In arbitration, it's not much different. Indian law and Singapore law and various other legal systems have that provision. Now, in response to that, there is a document that has evolved called the deed poll, which essentially is an undertaking which a funder gives at the stage of disclosure of funding, saying that there is no need to award security for costs in case the tribunal at the end decides that costs have to be awarded against the claimant. We undertake that we will pay those costs. We are a respectable listed company, or we are a respectable company with a capital of so many million, and therefore we undertake that in case costs are awarded against us, we will pay them. Now, these are the background concepts, and this is all in thin air, but like, how do we go about funding and where do you start? Obviously, securing funding for a claim is a complex task, and I can't give you a guide on how to get funding. Third-party funding is what is known in the financial market as an exotic financial instrument. Most commercial investors have very little knowledge of such an instrument and have little appetite for it. And especially in today's market, a lot of funders are unsure of getting into instruments that they really do not understand or have much visibility upon. Another thing that complicates funding is the lack of regulatory clarity, and this is compounded in multi-jurisdictional disputes where it's one party is in a different country, the law of the seat is different, the governing law of the contract is different, and therefore it just complicates the problem further. Based on my discussions with a few funders, I also noted a skepticism regarding funding India-related disputes, and a large part of that is because of both the perception and reality of how long it takes to get a conclusion of a dispute in India. And while there is some demand even for funders, that means no, there is some possible supply of funders. That means there have been some people who have shown interest in getting into this field. The lack of regulatory clarity has dissuaded them. This is also compounded in the given economic climate. But I'm going to try and give you a few practical insights that I learned on the job. And some of them comes from observations and discussions from my friends who are in this area, and some of the people who have complained that a lot of counsel who approach them for funding cases don't really know how to go about it, to say the least. Now, there is no standard protocol followed by all funders. You have a lot of big leading funders. You have Buford Capital, you have Vannin, you have IMF Bentham, you have Omni Bridgeway, and you have a lot of the big players, but nobody has a standard way of approaching things. But based on our experience, a broad procedure that I could possibly draw, and obviously this depends subject to the contract between the parties, a broad procedure that can possibly be done is set out here in this slide. Now, first thing, and I know this may sound rhetorical, but I cannot stress this enough. You need to prepare your case inside out. Unless you know your case inside out, there is no use approaching the funder, because then you are just going to cut a sorry figure very soon in the process. An advice, especially for people who are with the firms, open a separate file for the cost of funding, because even if a funder may fund the cost that you have already incurred in the arbitration, and that's subject to agreement, they are never going to fund the costs that you incur in trying to find funding. That means trying to find funding from multiple third-party funders. Now, before you start interacting with the funder, you have to send a conflict check. I understand that for some people who are with law firms, a few of these things are things I don't even need to say. But for the benefit of the students listening in, sending a conflict check is very important. You don't want to realize later that you've disclosed things and you have a conflict of interest, or the funder has a conflict of interest, or has some pecuniary interest in the party you're going against. The next thing is you signed an NDA or a confidentiality agreement with the funder. Now, depending on which jurisdiction you are in and what law of legal profession ethics applies to you, it may be different, but across the globe, you do have an obligation to maintain the confidentiality of your clients, as well as respect the confidentiality of the arbitration process. And because of that, you cannot disclose documents to your funder without having a confidentiality agreement. So sign an NDA, have a confidentiality agreement, and then only proceed to send any documents to the client. Which brings me to the next step. Send the documents to the funder along with an instruction note. Now, one representative of a leading funding company shared with me once that a lot of times when people approach them for funding, they actually dump all the documents in a very disorganized manner onto the funder. Now, the funder and nobody has time to waste. So please respect that and organize the documents well. I would suggest creating a cloud drive, putting all the documents there and sharing that with the funder. In addition to that, please make a proper instruction note. Now, what's an instruction note here? It's a broad outline of your case and facts and summary, and a summary of the facts. It's not an argument here. So please be objective. Please weigh the merits and demerits of your case here, because if you don't, they will still find out there is nothing you want to or will be able to hide from your funder. Then the next step is that the funder takes some time, goes through the documents, and if they're interested, then there happen a series of meetings which are either personal or telephone discussions, which are usually between the funder, the client, and the counsel. And in these, mostly the funder is asking very preliminary basic questions, trying to get a broad sense of the dispute. We have a question. Give me a second. Substantial costing. Yeah. So Kuar B. Singh has asked a very interesting and a very relevant question, that parties actually end up expending substantial costs in finding funding, and these costs don't get reimbursed. And is there a way to tackle this problem? The way to tackle this problem is to keep the costs of funding the least possible, but there is no way to get reimbursed for this funding. And appreciate there are legal and ethical concerns even for a counsel to try to get reimbursement for this funding, because then you may have a conflict of interest to drive your client towards the funder who may end up funding the proceedings and paying your bills. You have to appreciate your obligations are to your clients and not to the funder. So while this is a problem, and I realize the fact that substantial time, effort, energy, and subsequently costs are incurred in finding funding, currently there is no mechanism for reimbursement of those amounts. Now, I hope that covers your, that is the answer you were looking for. Now, we were on the stage of discussions between the funders and the clients. Yeah. Discussions between funders and the clients. Now, these discussions are usually spread over time. In our own limited experience, and you have to appreciate any experience in this area is quite limited because this is a relatively new concept. It takes a few months to go through the funding process. It's not a quick overnight or a 1 week process where you quickly go in and the funder agrees and writes your check. It doesn't work that way because there are various steps which punctuate each uh, each stage of the third party funding process. Now, once you have discussed at an advanced stage with your funder and the funder has internally discussed how good it may be for them to fund your case, then the parties sign what is called a term sheet. And the term sheet basically contains indicative terms on which the parties are likely to um, enter into a formal funding agreement. Now, while the term sheet isn't binding per se, some clauses of the term sheet are often agreed to be binding between the parties. For example, a lot of investors insist that the moment you sign the term sheet, you enter into an exclusivity period with them, which means for the next 30 days or 45 days or 15 days, whatever you agree, you do not negotiate or deal with other funders. Because till this stage, you can happily contact 10, 20, as many funders as you want. Yeah. Approaching each funder means additional costs for the client, and therefore that it is more of a commercial decision on behalf of the client which funders and how many funders they want to approach. But beyond that, you can be approaching multiple funders at the same time. Thereafter, once you sign the term sheet, the exclusivity period kicks in, and in that period, you usually only discuss with the particular funder with whom you sign the term sheet. And in parallel to this step, the funder is also doing due diligence. Now, due diligence means that they will check every single thing. Sophisticated funders and good funders have a reputation of getting your facts, your law, your documents, everything double checked. They often are willing to commit substantial amounts, and therefore they are happy to put in some money up front just to test how good your case is likely to be. And this means I've seen funders doing detailed asset tracing at this stage, which means that even before starting, and this what I'm recounting is a case of where uh, funding was done at a very early stage. So it's not usual for people to do tracing of assets at a very early stage in the arbitration, but sophisticated funders will often get an asset tracing report at this stage, even before committing or entering into a funding agreement. They will also often get second opinions. That means you've taken a strategy, they might run the strategy by another experienced legal team, or most top funders are themselves staffed with some of the best legal minds as well as people from an investment background. So they are also able to assess internally the merits and demerits of your case in a very objective manner. Now, in due diligence, some funders even look at how your tribunal has reacted on some issues in previous cases. And there are various other things that a funder may want to see. And that depends on funder to funder. Now, after that, the funders usually go get an in principle approval from their own investment committees. And most funders have investment committees which are staffed with some of the leading authorities or some people who are so experienced in this field that they have a very good understanding of the likelihood of success in a case. You have to appreciate, from a funder's point of view, all they are looking for is to win. Yeah. Yeah. So Ephraim has raised a point that it's certainly a risk and SWOT analysis needs to be done. And I completely agree with you. And it's the risk analysis is more of a commercial risk at this stage, and obviously it's legal risk also. But at the end of the day, this is an analysis of the commercial risks by the funder, and that becomes very important. And you see some of the funders are advised by people who really understand the process well. Yeah, so Ricky has made a comment that the whole process may take a lot of time, and that is absolutely correct. It's not a very quick process, and maybe as we go further at the end of the 20s, maybe this process becomes quicker and more streamlined. But right now, the process takes substantial time. Now, once the investment committee has discussed your case and is convinced of the likelihood of success, they give an in principle approval, and then you start negotiating the funding agreement. Now, the funding agreement is a very crucial document. The funding agreement is the key agreement that will govern the funding, that will also uh, take care of the relationship between the parties, and that will form the central piece of the whole funding arrangement. Now, how to get to that stage requires a fair bit of convincing, and it's not an easy process. The funding requires you to, the process requires especially the council to convince the funders that this claim is a stellar claim. So you obviously need to believe that yourself and understand, given the demand supply dynamics, funding right now is only available for stellar claims. So if you have a very good claim with a very high likelihood of success, that's what you take to a funder, and that's what you use to convince the funder that this is a good case for investment. And it's it's similar to convincing any venture capitalist to invest in a particular project. Not the same, but in some ways similar. From a legal perspective, it is an exercise in written, spoken, as well as social advocacy. And this is because the funders will only invest in cases on which they have a very high confidence. And confidence would have to be both on the merits of the case as well as the legal team handling it. And therefore, your written advocacy in how you have prepared your pleadings or the initial documents, your oral advocacy in how you are convincing the funder over a phone call on why this is a good idea, or even your social advocacy on how you are conducting yourself in front of the funder over a couple of drinks, all of this becomes very relevant. So there is a lot of advocacy and persuasion involved in this, because funders will fund cases on which they are comfortable in betting. And in this regard, I must say there is no scope for mediocre work. So both in terms of the merits of your case as well as your own work as a counsel, it has to be your A game and beyond. Now, sophisticated funders will do a lot of homework. Give me a second. I see a few questions. The funding agreement also includes an arbitration clause. Yeah. So there's a question. Oh, I've missed a couple of questions. Give me a second. So forgive me if I'm saying your name wrong. Adeyemi and Ephraim have asked a couple of very interesting questions. The first question is that does the funder get a right to nominate an arbitrator? And the second is, does the does the funding agreement include an arbitration clause? And the question of the arbitration loop. Um, the answer is it depends on the agreement and the negotiation. And I will address this right after I finish this short point. And these are all dependent upon the negotiation of the parties. So let me just put a pin to that and I will come to it. The next question I see is in a situation fund the funding for. Okay, so the next question is from Gurdeep. Says that a funder coming into play in India, we have time limits on arbitration processes, and then when you give disclosure, it may even lead to objections on the mandates of arbitrators. Now, one thing is for sure that substantial time, effort, energy goes into the funding process. However, it does not necessarily delay the proceedings because funding is a parallel thing. Your tribunal is likely to never give you extension of times because you are seeking funding from funders. So that usually never happens, and therefore these the process of arbitration and the process of funding can happen in parallel, and therefore it's not necessary that it causes a dilatory impact on your whole arbitration. Now, now let's come to the funding agreement, which brings me also to the two questions asked by people joining in here. And the funding agreement is essentially a contract. It's a contract that governs the relationship between two parties, the client and the funder. The law firms are usually not parties to those funding agreements, especially in jurisdictions like India and Singapore, where contingency fees are not allowed. The thing is a little different in countries like the United States, where some funders insist that some law firms do part contingency and part funding, and a part of it is funded by the client himself so that he has some skin in the game. But in countries like India, essentially it depends, or even in Singapore, it depends on the agreement of the parties. Now, this is a contract that you negotiate, and it's a tricky negotiation often because you have to foresee a lot of problems which may possibly arise in the enforcement of this agreement, and therefore you also have to see whether or not you want to include very specific express clauses. The practice usually is that funders prefer to err on the side of caution and give express clauses, and therefore it becomes very important for the counsel to keep in mind a lot of key things while drafting these agreements. Having said this, there is also a lot of scope for innovation in these funding agreements. For instance, you can not only just get funding for your arbitration proceedings, but like we recently saw in a case, parties can also get funding for their operational costs. That means if a party is going into litigation in arbitration and they have let's say an unpaid invoices claim, but they do not have the funds to pursue the litigation, or even if they go ahead with the process, it will mean that they will have to divert substantial funds from their operations, and it may lead to the company going down under. And therefore, there's a lot of scope for innovative arrangements whereby the funder can even extend help with the operational costs of the company who is seeking funding. And that becomes something very interesting and something that can be tailor-made as per the requirements of the particular case. I do see a few questions. If you would excuse me, I have a few points, short points to cover regarding the funding agreement. And once I'm done with that, let me come to the questions. Now, a few things you need to keep in mind while negotiating a funding agreement or even understanding how these agreements work. First is war chest. What war chest do you need? That means how much money do you need? There are often cases where councils seek budgets which are near about in the range of 10% of the total amounts that are likely to be recovered in the arbitration. And issues of other advances like working capital advance that you may require from the, if you just come up with a figure, a funder will require you to give a very detailed particularization of what amounts you're claiming. And that would mean that you will have to break down each and every cost and the foreseeable costs. Obviously, you can only break down the foreseeable costs. And therefore, most counsel, while preparing a budget, like to slightly err on the side of caution and be a little less conservative about their estimates. The next thing you need to think about is issues of control. Who has the steering wheel and who has the brakes? Now, the decisions regarding when to settle, how to pursue, which counsel to continue with, all of these are issues of control. Who gets the control depends on the agreement, but mostly the control stays with the party. Most funders offer their advice and their opinion and suggestions about how to go about it. But again, the experience in this area is limited, but the limited experience shows that there hasn't been many instances of much meddling by the third party funder. And funders often offer the clients project management services, which means that they tell the client that, guys, we have done this so many times and we know how to run an arbitration better than you do. So how about we assist you in taking charge of the proceedings and keeping the lawyers and the experts and everybody on the same page. Some clients agree on that, some clients don't. As I said, it completely depends on your negotiation. There may be desperate cases where a party really needs funds and therefore has less negotiating power, and there may be situations where you may enter into an agreement where the funder gets right to suggest the choice of arbitrator. This is a tricky situation, and before you enter into such an agreement, I would strongly recommend that you see what is the law applicable to you, what are the mandatory rules of the seat of arbitration that may apply to such a situation, and other conflict of laws issues that you should look at in such a situation. The next issue is issues of payment. Now that becomes very interesting. Most funders that I have had limited experience with prefer a sliding scale of payment. That means progressively, as more and more time elapses, their returns increase. That means if the matter gets settled or decided in 1 year, you get X amount. If it gets decided in 2 years, you get 2X amount or Y amount, and progressively like that. So they often have a sliding scale. And the test event is when the money comes in. It's not when you win the award, not when you filed for execution. It's when you actually get the money. So that's the date on which you measure it. And it again depends, how much you pay the investor depends completely on your negotiation. And that's usually a negotiation that has to be conducted very carefully. Now, there are further issues that you must think about. Now, I wish I had a couple of hours each to go into these points, but I don't. But you must think about the issues of confidentiality, of documents and of the proceedings, of disclosure, and how disclosure of particular documents may affect your client, as well as issues of privilege, attorney-client privilege, and all of these. These are each individual topics on which a lot of discussion can be done. But if you want guidance on this, may I suggest looking at the Queen Mary Arbitration Task Force on Third-Party Funding report. That's a good starting point. The last thing I would want people to think about when they're getting into such agreements are public policy concerns. And that is amplified in situations, especially in India, given the historical outlook of the courts on issues of public policy. Now, while the Supreme Court of India, in a judgment I was reading, in the judgment of Bar Council of India versus A.K. Balaji, and the citation is 2018 5 SCC 379. It is said in paragraph 38, and this is a direct quote, there appears to be no restriction on third-party non-lawyers funding litigation and getting repaid after the outcome of litigation. The court further goes on to say that third-party litigation funding / legal financing agreements are not prohibited. Now, while this judgment is about the entry of foreign law firms in India and is not specific to third parties, is one of the few limited guidance available on the regulatory framework of third-party funding in India. And therefore, you have to foresee a situation where the respondent tries to challenge the award, and one of the grounds he takes is that the funding agreement was against the public policy of India, given the historical champity and maintenance rules. I will not go into the details of that, and there is a lot of excellent literature available on this online. And in case you're interested in it, I suggest that you go look it up further. But you do have to be mindful and foresee and advise your client about these risks